Senator Professor Tom Ojienda.
Mr. Speaker, I wish to address a few issues on the preliminary objection that has been raised before this House this morning. Mr. Speaker, there are two issues. The twin issues, one, Mr. Speaker, touch on the propriety of these proceedings and whether or not the proceedings before the Assembly, Mr. Speaker, under Article 181 and Section 33 of the County Government Act, my Lord, Mr. Speaker, are a continuum. In law, Mr. Speaker, the process that defines the commencement of impeachment proceedings, Mr. Speaker, and it is instructive to note, has now been settled in terms of what constitutes a process. And Mr. Speaker, the Majority Leader, Senator Aaron Cheriot, has referred to two decisions that have informed prior impeachments in this House: the impeachment of Ferdinand Waititu and the impeachment of the then Governor of Nairobi, Mike Sonko. Both, Mr. Speaker, were my clients at some point. I've therefore had the advantage of litigating on impeachment. But, Mr. Speaker, I will proceed to the first objection. Mr. Speaker, the proceedings of this House are cushioned from any other processes. And, Mr. Speaker—
Order, Senator Tabitha, please.
The proceedings of this House are cushioned from any other processes. When this court sits to hear impeachment proceedings, we sit as a court. And, Mr. Speaker, because all the issues will be canvassed here, what was raised by the counsel for the governor as preliminary objections do not strictly in law qualify as preliminary objections, because the House has been asked to look at various exhibits and to see various videos. That is the province of evidence, Mr. Speaker. On that account alone, the preliminary objections will collapse, because there are two interpretations of the whole number in the Nkadude case, Mr. Speaker, and in other decisions. This Senate would have to sit and consider all the submissions from parties to arrive at a proper finding as a jury at the end of this process and when witnesses are called. The magical number, Mr. Speaker, 31 and 32, 31.3, that the whip Kalwale was referring to as res ipsa loquitur, Mr. Speaker, is not quite res ipsa loquitur. The facts are not obvious, because the interpretation and the tilting of all numbers between 31 and 32 are matters of evidence and presentation before this House. And that we have seen from the submissions by the County Assembly and from the other side. Mr. Speaker, I've had the advantage, and I must say this, of litigating the question of continuum in the Wambora case, the case of Marete, Kauma, and Honorable Nyaga Wambora, which was civil Supreme Court petition number 32 of 2014, where the court, in summary, in dealing with Hassan Joe, Said Shabal, and other decisions, my Lord, Raila Odinga, and in citing the National Assembly Privileges and Immunities Act, Section 12, my Lord, Mr. Speaker, insulate this House from any contempt proceedings, number one. But number two, Mr. Speaker, it also insulates this House and other institutions from any claim of interference by other institutions. The Supreme Court, Mr. Speaker, in that matter, defining the independence of institutions as a primacy that must be considered, and the Supreme Court holding our petition in 2014 on the basis, Mr. Speaker, that this House cannot be injuncted by a court. The orders issued by Judge Sergon, Mr. Speaker, cannot therefore stop the proceedings of this House. Mr. Speaker,
just 1 minute.
Mr. Speaker, just to note that a dark cloud hangs over the head of the governor, over the allegations that have been made. What other place would the governor have to clear the allegations made against him other than in this house? I think this is the opportunity for the governor and for the county assembly and the people of Kericho to know whether or not the governor is guilty or innocent of the wrongdoings that have been leveled against him. Mr. Speaker, allow this Senate to make a decision on this matter by going through a substantive hearing of all these allegations. Thank you, Mr. Speaker.